All right, welcome back everyone to the afternoon portion of the Oregon Water Resources Commission meeting. We are on agenda item E, and we have it's in the matter of water right application R87871 in the name of the East Valley Water District. Further proceedings and oral arguments. And right now I'm going to turn it over to our legal counsel, Jesse Radcliffe, to walk us through some process.
Thank you, Chair. And I'm actually going to pass it first to Elliot, who is going to give kind of the introduction to the agenda item, and then he'll hand it back to me.
Sorry about that, Elliot. Yes, we have a request from Commissioner Newman.
Sorry, I just want to state for the record, this is Jan Newman, that I'm recusing myself from this discussion because of prior involvement in the case.
Thank you. Go ahead, Elliot.
Thank you. Vice Chair Smitherman, members of the Commission. For the record, my name is Elliot Crafton. I'm the Water Rights Section Manager for the department. On August 7th, 2025, the Oregon Supreme Court issued an opinion in the matter of water right application R87871 in the name of East Valley Water District. The Supreme Court affirmed in part and reversed in part an earlier decision of the Court of Appeals and reversed the final order issued by the Water Resources Commission denying East Valley Water District's application to store water. The Supreme Court remanded the case to the Water Resources Commission for further proceedings. Pursuant to the Supreme Court's remand, the Water Resources Commission considered the application at its meeting on December 11th, 2025, and issued a proposed final order on remand on December 18th, 2025. The proposed order provided the East Valley Water District, the applicant, and Water Watch of Oregon, a protestant in the original proceeding, an opportunity to file written exceptions, as well as an opportunity at a future meeting to present oral arguments related to such exceptions. Today's agenda item provides the parties with their opportunities to present oral arguments. Following oral argument, the Commission will enter executive session pursuant to ORS 192.660 sub 2 sub F to consider written legal advice and then reconvene to identify further proceedings. As a brief background to the matter, East Valley's application is an application to store 12,000 acre-feet of water in a reservoir constructed on Drift Creek, a tributary to the Pudding River. The Commission denied the application based on a determination that the public interest presumption under ORS 537153 had been overcome. The Commission reached the conclusion based on public interest factor ORS 537.170 sub 8 sub F, which requires consideration of all vested and inquit rights to the waters of the state or to use of the waters of the state and the means necessary to protect such rights. The Commission found that the proposed appropriation impairs or conflicts with the beneficial purpose of Certificate 72591, an existing in-stream water right, and that there is no basis to conclude that the means to protect the right are available in this instance. The Court found that the Commission correctly interpreted that the statutorily protected public interest in vested and inquit water rights applied to both the quantity of water guaranteed to the senior water right holder and the beneficial use associated with those water rights, and that not protecting this public interest right may be a valid basis for denying an application. However, the Court also held that having determined the public interest presumption was overcome, the Commission was obligated to consider all 7 public interest factors in ORS 537.170 sub 8 in evaluating whether the proposed appropriation would impair or be detrimental to the public interest. The Court remanded the final order back to the Commission to consider each of the public interest factors and issue a new final order on the application. The Commission issued a proposed order on remand on December 18th, 2025, which proposes to deny the application. Within the proposed order, the Commission included sections on consideration of the ORS 537.170 sub 8 public interest factors, as well as a balancing of the public interest factors. Though the order clarified that the inclusion of such balancing does not reflect a policy or practice of the Department or Commission with respect to evaluation of any future application. Because this matter was remanded to the Commission in the first instance, the Department has not provided a recommendation on this agenda item. And now I'll hand it over to Jesse Ratcliffe, who will provide additional information with regard to the presentation of oral arguments.
Thank you, Chair, members of the Commission. For the record, this is Jesse Ratcliffe with the Oregon Department of Justice. And so I'm just going to go over a couple of quick notes here before we get into the oral argument presentations from the parties. So first of all, as you're aware, exceptions were timely filed by both East Valley and Water Watch. So we will be hearing presentations from both of them today. A couple of notes about the presentations. So the way that exceptions were structured here was that there was simply a presentation of exceptions without responses. So in other words, the parties were not given an opportunity to respond to each other's exceptions. That's fairly typical for the exceptions part of the process in administrative hearings. What that means today for the presentations that you're going to hear is similarly the parties should be presenting to you rather than, kind of as against each other based on the written exceptions that they filed. In addition, the record is closed, so the oral presentation should not contain references to any evidence that was not a part of the record as it was presented to the court on appeal. So the time limit that was established for the oral presentations is 15 minutes for each party, inclusive of questions. The commission should feel free to jump in with your questions as they arise. There's no need to wait till the end of the presentation, as the attorneys who will be presenting are they're used to this. This is kind of how it works in appellate courts or circuit courts. You can jump in as you feel free. So with that, I'll hand it back over to Chair Smitherman. I guess one last thing I should note is that since the exceptions aren't responsive to each other, the order of presentation here doesn't really matter today, and so you're free to call up whichever party you please here to start. Thank you.
Thank you, Jesse. Thank you, Elliot. I think we will just go ahead and start with Water Watch. I'm not sure. Mindy, do you have she's on it. We have a timer.
Okay, I think, is the mic working?
Yes.
Yes, okay. Good afternoon, Vice Chair Smitherman, members of the commission. Thank you for the chance to comment today. My name is Brian Pozowitz. I'm a staff attorney at Water Watch of Oregon. I've been representing Water Watch on this case since it was referred to contested case back in 2016 with the help of another attorney in the appellate process. I will be pretty brief today, and as Jesse told you, we were advised to not use this time today to try to respond to exceptions of the other side. And so I will not be trying to do that today. And I'm glad you all understand why I'm not doing that. Water Watch supports the proposed final order on remand, the proposed final order that's before you. We believe it correctly frames the work to be done on the remand from the Supreme Court, and we believe it correctly does that work. In 2019, the Water Resources Commission decided unanimously that putting a 70-foot dam and a 12,000-acre-foot reservoir in the middle of Drift Creek without fish passage, flooding 3 miles of the flowing stream, would frustrate the purpose of an in-stream water right on Drift Creek for the benefit of cutthroat trout. Thus, the commission said the proposed dam and reservoir would impair the public interest in protecting existing water rights, which is one of 7 public interest factors that get considered in the review of a proposed new water storage project under ORS 537.1708. The Oregon Court of Appeals affirmed that decision entirely. The Oregon Supreme Court affirmed that decision mostly, but sent the case back to you for the very limited purpose of expressly considering the other public interest factors and whether they somehow outweigh the impairment of public interest that you found would occur in protecting existing water rights. We believe the commission already did that analysis back in 2019. That is, considered all of the public interest factors, at least implicitly, when it made its decision in 2019. One of the justices on the Supreme Court thought so too, and explained that in a dissenting opinion, and we agree with that opinion. In other words, we thought that all the factors were considered back in 2019, and we agree with the comment made at the last meeting that the commission just really needs to show more of its work on remand. In any case, we agree that the thing to do now is to simply explain your consideration of the other statutory public interest factors and why they do not outweigh the impairment of public interest that would occur here in the public interest in protecting existing water rights. The proposed final order would do that. It would expressly explain your consideration of all the public interest factors and why they don't outweigh the impairment that's been found as to the public interest factor in protecting existing water rights. The Supreme Court did not direct you to reconsider any other issues in this case, and it certainly did not direct you to reconsider the decision that was made in 2019 that this project would impair existing water rights through its impairment of the in-stream water right. So in short, we support the proposed final order. We did file some exceptions to the proposed final order, and that was primarily just to preserve certain arguments in the event of any further appeal on this matter and for future cases. In general, our exceptions say that this application should have been denied for reasons in addition to the reasons given in the proposed final order before you now, including our view that it would impair public interest factors in addition to the factor that protects existing water rights. Our arguments to that effect were fully briefed in our exceptions because we made the same arguments back in 2019. They were fully briefed in 2019, and so our exceptions as to this proposed final order simply incorporates by reference those prior arguments and cites to them. In short, we believe that putting a dam and reservoir on Drift Creek would just do too much damage to the fish, wildlife, and water quality of Drift Creek at a time when the state is spending an estimated $10 million a year to take dams out of streams, and that's in the record, and at a time when this agency's integrated water resources strategy says, quote, Oregon has moved away from locating dams on significant stream and river channels, in large part because of effects on fish and aquatic life that must migrate through these streams. We believe the application also would impair the public interest because it would take land for the reservoir from local farmers who don't want this project and who fought alongside of us in the contested case to defeat this application. And several of those farmers, by the way, are in the room today watching these proceedings. Finally, we believe that the record shows that the members of the irrigation district already have water rights for their crops, and that to the extent they need more water, there are less destructive alternatives for them to get that additional water. But you really don't need to reach all of those issues about how this impacts other public interest factors that we think also support denial of this application, provided that you simply adopt the proposed order before you and deny the applications for the reasons given, which we fully support. Thank you for considering my comments, and I would be happy to answer any questions.
Commissioners, do we have any questions? Doesn't look like we do.
Okay.
Thank you.
Thank you.
Thank you for your presentation. Okay, next up, it's Valley Water District.
Good afternoon. For the record, I'm Kirk Mogg, a partner at Stoll Reeves, and with me is my colleague Haley Siltonen. We are here today representing East Valley Water District. The water right application before you today is the culmination of a decades-long effort by multiple generations of farmers seeking a reliable and sustainable source of water. The application is the result of years of collaboration between the applicant and the Water Resources Department. It's also the result of hundreds of thousands of dollars of investments, both by local farmers and the state of Oregon. The outcome of this case is of the utmost importance to the future of water management in Oregon, and the impact of today's decision will be felt far beyond East Valley Water District's boundaries. It will affect every new water right application in Oregon going forward. The question before you today is whether East Valley's proposed storage of water is in the public interest. The answer, yes. The approval of East Valley's application will support multiple beneficial uses of water, will maximize economic development, will increase stream flow and reduce water temperature, and will advance Oregon's prosperity roadmap. In contrast, the denial of the application would elevate in-stream water rights above all others, would undermine economic development, would tolerate the poor habitat conditions that exist on Drift Creek, and impede Oregon's prosperity roadmap. The proposed order identifies only one reason why the proposed storage might not be in the public interest: potential impacts to cutthroat trout habitat. The Court of Appeals in this case scoured the record and identified only limited evidence to support the Commission's finding that the proposed reservoir could conflict with the habitat needs of cutthroat trout. That's because the bulk of the evidence in this case demonstrates that habitat conditions on Drift Creek are poor and that the proposed reservoir can be operated to improve habitat conditions for the benefit of cutthroat trout. Based on that evidence, and as further explained in Section 3A of our exceptions, the Commission should issue a final order approving the application. However, if the Commission still has concerns about the potential impact to cutthroat trout, an easy solution exists. Approve the final order with an additional permit condition, as explained in Section 3B of our exceptions. East Valley's exceptions propose the following condition to protect the purpose of the in-stream water right on Drift Creek. That condition reads, "The use of water allowed herein may be made only at such times when sufficient water is available to provide required stream flow for the migration, spawning, egg incubation, fry emergence, and juvenile rearing of cutthroat trout within the reach of Drift Creek described in Certificate 72591. Page 5 of the Commission's proposed order states that there's no basis in the record to conclude that East Valley's proposed storage of water can be conditioned to protect the purpose of the in-stream right. But that conclusion is not supported by substantial evidence in the record. Conditions are customary in all modern water use permits. In this case, the director's final order approving East Valley's application included a dozen different conditions, including conditions related to wetland mitigation, riparian habitat mitigation, and water quality, just to name a few. East Valley's proposed condition to protect the purpose of the in-stream right would function just the same as these other conditions that are already proposed to be included in the permit. It's true that East Valley did not propose a specific permit condition regarding the in-stream right before the record closed in this case. But that is entirely unsurprising because the Commission did not announce its new interpretation of public interest factor F until after the record closed in this case. Moreover, nothing requires that the permit condition be proposed by the applicant itself. The Commission has the authority, the responsibility to add a new condition to ensure that the in-stream right on Drift Creek is protected. And evidence in the record demonstrates that East Valley's proposed permit condition would be sufficient to protect the purpose of the in-stream right. Here, ODFW and DEQ already recommended conditions to protect habitat of certain listed fish species, including winter steelhead. and the Commission accepted these conditions as protective of those listed species. These conditions require East Valley to mitigate the impact from the dam and reservoir on Drift Creek fish populations. The director found that, quote, evidence from fish and wildlife experts suggests that water may be stored in Drift Creek while conserving water usage and habitat for fish and wildlife, end quote. The director further found that the evidence in the record did not support WaterWatch's argument that the conditions would be ineffective. Although cutthroat trout are not a listed species, they are members of the salmonid family, just like winter steelhead. The fact that ODFW developed conditions to adequately protect winter steelhead strongly suggests that the proposed use can be conditioned to adequately protect other salmonid species like cutthroat trout. Nothing in the record suggests otherwise. In fact, the director specifically rejected arguments that conditions to protect listed fish are inadequate to protect non-listed fish species. The proposed order suggests that more information would be needed to develop conditions to protect in-stream water rights. This finding is not supported by the record. East Valley's application contained all information that's required by law, and that information, plus the additional information developed through the contested case proceeding, was sufficient to develop all of the other permit conditions. These are the dozen plus other permit conditions that are already included in the director's final order. That same information is sufficient here. With the addition of a condition to protect the purpose of the in-stream right, the Commission can avoid any potential impairment of or conflict with the beneficial purpose of Certificate 72591. That's the in-stream water right. In other words, if the Commission were to adopt East Valley's proposed condition, no further analysis of the public interest factors would be required because the purpose of the in-stream water right would be protected and all 7 factors would weigh in favor of granting the application. Does the Commission have any questions regarding the proposed condition to protect the purpose of the in-stream water right?
Don't think so. Thank you.
So then moving on, but even if the Commission does not adopt East Valley's proposed condition to protect the purpose of the in-stream water right or a similar condition, the only way for the Commission to advance the public interest in this case is to approve the application, at least based on this record. When this case was before the Commission in 2019, the Commission erroneously denied the application based on its consideration of a single public interest factor. Because of that error, we're back here today. Despite the clear directive from the Supreme Court, the proposed order again proposes to deny the application based on a single public interest factor. The proposed order suffers from several critical flaws. The public interest test only makes sense if all 7 of the factors are considered and weighed against one another. This conclusion is consistent with the legislative history underlying the applicable statutes, including testimony from WRD Director Pagel and testimony from WaterWatch. Despite this requirement, the proposed order relies entirely on one public interest factor to deny the application without meaningful consideration of how other public interest factors weigh in favor of approval. The proposed order has a singular focus on one potential impact to the public interest. But you as commissioners have an obligation to consider the significant public interests that would be advanced by granting the application. Similarly, you have an obligation to consider the detriment to the public interest that would result from denying this application. The proposed order ignores the numerous ways in which approving the application would advance the public interest. For example, approving this application would support multiple beneficial uses of water on Drift Creek. It would maximize economic development. It will increase stream flow and reduce temperatures in the late summer months downstream from the proposed reservoir. And approving this application advances Oregon's prosperity roadmap. The proposed order also fails to consider the detriment to the public interest that will result from denial of the application. Denying the application would preclude additional beneficial uses of water on Drift Creek. It would undermine economic development, threaten the stability of water supply for Willamette Valley agriculture, ignore the public and private investments that have been made in this project. It would tolerate the poor habitat conditions that exist on Drift Creek and impede Oregon's prosperity roadmap. The proposed order also conflicts with the public interest by elevating in-stream water rights above all other water rights. But the Oregon legislature made clear when it created in-stream water rights that quote, an in-stream right should have the same legal status as any other water right. Despite this clear statutory command, the proposed order purports to recognize a special significance in in-stream water rights. This can't be squared with applicable law. The impact of the Commission's decision today will reverberate far beyond East Valley's boundary. That proposed order has far-reaching implications for all new water projects in Oregon, and the Commission must consider these implications when evaluating the public interest. Most surface water sources in Oregon are overappropriated. And as you know, declining groundwater levels are a serious concern throughout much of the state. New storage is one of the few options available to provide an alternative source of water to meet existing and growing demands. The public interest in expanded water storage capacity is clear. Organizations that provide water to the great majority of Oregonians, including the Oregon League of Cities, Oregon Water Utilities Commission, and Special Districts Association have all weighed in regarding this case to sound the alarm about the threat to their ability to obtain new water rights, jeopardizing their ability to deliver water to their current and future customers. They are concerned that allowing a single public interest factor to override the broader public interest will threaten all new water right applications. And if the public interest test is extended to transfers, as has been proposed, the Commission's approach here will also threaten all future water transfer applications. The proposed order before the Commission today is not supported by substantial evidence in the record and does not reflect the careful consideration of the public interest factors required by statute and the Oregon Supreme Court remand order. Your careful consideration of the public interest cannot ignore the benefits of the proposed use or the harm that would follow from denying the application. The Supreme Court explicitly anticipated that the Commission's decision today would likely differ on remand because of the need to balance the competing public interest. Yet the proposed order that's before you today is largely a repeat of the Commission's prior analysis. As explained in our exceptions and in my remarks today, the only way for the Commission to advance the public interest is to approve East Valley's application. Thank you. Are there any questions?
Questions, Commissioner Lee?
Oh, there. Okay. I went through the 2019 proposed final order.
Commissioner Lee, can you bring the microphone?
Oh, sorry.
Thank you.
I went through the 2019 proposed final order, and I saw that all of the agencies who reviewed it thought it could be accomplished if conditions were met. And I particularly looked at the statement that was made by Tom Mortaugh of ODFW, who realized that there would be fish passage or the alternative, as the applicant indicated, and that wetland delineation could deal with the inundation factor. So what I'm wondering is if this commission was to approve your new proposal with that condition in it, if your applicants would be willing to go ahead and build the reservoir, or if they still have considerations to further discuss.
Thank you, Commissioner Lee. If the Commission were to approve the application with the proposed condition that's included in our exceptions, East Valley absolutely intends to move forward with this project, recognizing that there are numerous other permitting processes and approvals that are required. I would also say that we believe that the conditions that already appear in the proposed order that the conditions that are already in the proposed order that relate to listed species are sufficient to protect other salmonids that are non-listed, like cutthroat trout in this case. So whether it's with the current conditions that exist in the director's final order or the addition of the condition proposed by East Valley, that would allow East Valley to move forward with this project.
I was originally concerned about the inundation, but my understanding is that if the rolled concrete dam were to be installed, as had been talked about in the past, it would release cold water and stream. And I wondered if that would have a higher value for the fish than what would be caused by the inundation if the wetland delineation went forward.
Commissioner Lee, there is ample evidence in the record to support the conclusion that the reservoir can be operated to release cool water later in the season, which will provide a benefit to and combat the primary obstacle to cutthroat trout rearing habitat that exists on Drift Creek.
Thank you.
Thank you. And I know we went a little bit over time, so just want to extend another minute and 15 seconds to Water Watch if necessary, but not as a rebuttal or anything, if there was anything else you wanted to add. Okay. I'm just trying to be fair with the time, so thank you.
Thank you.
Okay, so we do have some advice here from our legal counsel. I propose we do take some time for an executive session. Do the rest of the commissioners concur with that?
Yes.
Okay, everyone is nodding. So we will move forward with executive session. The Oregon Water Resources Commission will now meet in executive session pursuant to ORS 192.6602F, which allows the commission to meet in executive session to consider information or records that are exempt by law from public inspection. Specifically, the commission will meet to discuss attorney-client privilege legal advice pertaining to the Supreme Court's remand of the commission's final order on the East Valley Water District's application R-87871. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room, or we will be leaving the room. Is that correct? Are we going back upstairs?
Chair, I think we are going back upstairs.
Okay,
Yes.
sorry about that clarification. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decision will be made in executive session. At the end of the executive session, we will return to open session and welcome the audience back into the room, or we will come back into the room. I think that I'd like to allow a good portion of time for this discussion. So it looks like our next, would it be appropriate for an hour? What do other commissioners think about the time? Half hour, 45 minutes, an hour? Okay, okay. Maximum of an hour. I think we could start a little bit earlier, so just be ready. But I think give us enough time to really thoroughly have a discussion about this, and we'll be back at 3:00. Thank you to everyone for their patience. We are back reconvening from our executive session. Now we will go into discussion. If there's any commissioners that want to speak up about what's before us, ask any questions, talk amongst ourselves, now would be the time. Commissioner Lee.
Yes, my opinion is the department originally in 2019, I think it was, approved this. And the agencies who reviewed it agreed that if the conditions were met that the department requested, that they would approve it. So I think second guessing it now and second guessing it even a few years earlier was inappropriate. The other thing, I'm sorry. The other thing that I was concerned about is the applicant has said that they will honor the senior water right. All along, I don't see any evidence that they said that they wouldn't. And they also said that they would deal with the fish passage issue and with the wetlands delineation for inundation. So I could not vote for going forward with the remand.
Thank you, Commissioner Lee. Other commissioners have any thoughts?
Sure, I can reflect just a little bit on the commission's consideration of the public interest factors and this question of subsection F being the point. I do think that we as a commission have been called upon both by design and increasingly in recent years to look at patterns of action and behavior by the department and redirect and sometimes disagree with those. I think it's well within our charge as commissioners to do that. And I find it appropriate in this case that given the public interest factors that we considered and that one particular one that we decided upon, that it still makes sense today.
Thank you, Commissioner Mall. Commissioner Wolf.
Yeah, I think it's appropriate for myself, not having been involved with the prior process like Commissioner Mall was, to focus on not just that it's an in-stream water right, but that it's a senior water right that is potentially injured, and the prior appropriation system is one of the largest foundations for the way we deal with water in the state, and I will be focusing on the fact that it's a senior water right.
Yeah, I think I will also consider that as well, Commissioner Wolf. That any decision here today is not based on putting one water right above another, but to recognize that this is a senior water right that we're looking at, and not just an in-stream water right. So that is partially what will make up my decision today. Again, this is very difficult. Just acknowledge that. Okay, this is we've been put in the position to make a very difficult decision, and we have been very thoughtful. There's been a lot of great discussion, not specifically about this, but about our legal rights. And I think that at this point that we are probably ready to make a motion on this issue. So I will entertain a motion at this time.
Happy to do that. I move that the commission direct the department to issue a final order consistent with the commission's proposed order on remand, and providing the commission has considered and denied the exceptions filed by East Valley Water District and Water Watch.
Second.
Okay, we have a motion and a second. I'll take a vote. Commissioner Lee? No. Commissioner Wolf?
Yes.
Commissioner Mall?
Yes.
And I also vote yes. Motion passes. Thank you for being here today for that very difficult decision. We will now take a very quick break. About 10 minutes, I think, should be sufficient, and then we'll get back on track for the rest of our meeting. Thank you. Hey, welcome back. We are back from our break. We will be moving on to agenda item F, which is our director's report. Director Gall.
Vice Chair Smitherman, members of the commission, for the record, Ivan Gall, Director for the Water Resources Department. Yeah, I'll be providing a kind of a number of updates here. One, I'd focus a little bit of attention on item B in the director's report, the drought update there. I think suffice it to say that we have an unusually low snowpack across the state. I see we're 50 degrees today and warming trends coming next week. So it's been a really interesting winter to see how it has unfolded. I hearken back to the days of the old timers saying, don't worry, we still got time to make up the snowpack and everything, but we are fast running out of that in any practical sense. It looks like we're going to start out the irrigation season with very low snowpack, perhaps record lows there. The good news is we did get significant precipitation earlier in the year, so I hope soil moisture profiles are fairly wet to start with there, but we may have fingers crossed for spring rains to kind of try and make up what differences we can there. Kind of transitioning here, Bryn is going to touch on a legislative update, but I wanted to point out one bill that we've spent a significant amount of time on. This is House Bill 4049. Representative Mark Owens out of Harney County has introduced this there, and it largely focuses on the voluntary agreement framework for groundwater users within a single reservoir. So we've talked about this with respect to the Division 512 rule process that we wrapped up in December. The statutes do allow for groundwater users in a reservoir to enter into a voluntary agreement, or we could have multiple voluntary agreements to manage groundwater in lieu of other orders and rules of the commission. And so this bill was introduced, and we've been engaged in some pretty significant conversations led by Annette Leba and Justin Iverson, working with Representative Owens and his team to sort of supplant the proposed legislation with a new version of a guidance document. That work continues. Progress is being made. We're certainly getting a clearer understanding of how the groundwater user community would view and could use voluntary agreements there, but we'll keep you all updated as that unfolds. I'm pleased to share the good news that the Senate did confirm 2 new members of the Water Resources Commission. So Adele Amos, who's a law professor at the University of Oregon, will be replacing Joe Mall. That'll be effective April 1st. So Joe will be with us on our March meeting there. And then Travis Trumbull, who's the irrigation district manager for the Walla Walla River Irrigation District out in Milton Freewater, he was confirmed as well. So he'll be replacing Eric Quimp's seat there and filling that seat. Their first meeting will be that early June commission meeting. As soon as April 1st hits, we'll start doing some onboarding processes for them and try and get them up to speed on the various issues that you all are working on. Harney County also, I think you all were copied on an email or series of emails earlier this week from Commissioner Rob Frank. He, on behalf of Harney County and I think the city of Hines, has raised issues around the critical groundwater area rule and the land use nexus there. So very much what we were talking about this morning. So we'll be working to get him a response to those questions that he's posed. And we'll, again, share that information with you when we get that pulled together. Let's see. I wanted to share, I spent a couple hours, about 2.5 hours this week, actually taking a virtual training from the Oregon Government Ethics Commission. And I just wanted to share that it was very fast and intense. They pack a lot of information into 2.5 hours. I don't know how many of you have had the ability and time to take that yet, but I do highly recommend it. It's very relevant to much of the work that we do. Touches a lot on the public meetings laws, executive sessions, and just the appropriate, way in which to handle all of those. They also provide a very helpful list of references, and they themselves are available to help with questions as they come up. A number of our staff have taken the training to support meetings like this, but I was really pleased at what a good use of time it was for me there. And that's really all I have. Happy to take any questions from you on any of these issues in the director's report or anything else that's on your mind.
Anything else?
Water related.
Yes, thank you. Do we have any questions for Director Gall? No. Okay, doesn't look like we have any questions. Thank you for the information though in the packet.
You're welcome.
Much appreciated. All right, we have one more agenda item for today. The agenda item G, the much awaited budget and legislative update. Bryn Hudson is here to give us that update. I apologize, I did not introduce you or welcome you, Lisa.
We have to do it again? Oh, when it's red, it's, but you turned it off. I'm sorry.
No harm.
Okay. Bryn Hudson, Legislative Coordinator.
And Lisa Snyder, Administrative Services Division Administrator.
Make sure you press the button. All right, here we go. So we're here today to give the budget and legislative update. We'll start with happenings of the 2026 legislative session, and then we'll dive into some reminders of the legislative and budget overview development process, and then give an update as to where we are at in development for the 2027 legislative session, which is kind of wild that we're talking about that already, but that's the nature of the hamster wheel that we're on. Go ahead. All right, so we are in the midst of the short legislative session. So even numbered years is where we do the short session. Session goes from February 2nd to March 8th. So if you can do the math in your head, we just have a little over a week left of the short session. There are bill limitations. So we are tracking around, there's about 300 bills versus 3,000 bills in the long session that are introduced. We're still tracking about a third of those. That has gone down as session has gone on further, but we're typically looking at budget adjustments and smaller policy issues during short session. The larger policy topics and biennial budget development is happening in the long session. We'll get to that later. But the next major deadline that we are marching towards is actually today, which is, we call it the second chamber deadline, which means that bills that are in policy committees must move out of those policy committees to remain active. That deadline does not apply to revenue committees, rules committees, or joint ways and means committees, which coincidentally, most of the bills that we are tracking right now are in those committees. So, but that's just a kind of a process overview. And then constitutionally, the session ends March 8th, unless they finish before or unless they extend that deadline as well. So go ahead. So attachment 1 of the staff report provides a more substantial overview of the bills that we are tracking. I'm just going to highlight a few today for the purposes of keeping things short and sweet. House Bill 4004 is the primary piece of legislation that we are tracking that has the most substantial water policy concepts in it. I will go through each of those because I'm sure you don't know what any of that means based on the bullet points. But one topic in here is around the dam safety principal assistant position that we have currently sitting at the agency. This was an issue that was actually identified by the Department of Administrative Services as they were reviewing our agency structure. So we currently have a statute that requires the director or a principal assistant to be a registered engineer experienced in water-related engineering. And currently, our principal assistant is our state engineer who serves as the dam safety manager and reports to our technical services division administrator, along with all of our other technical experts at the agency. Principal assistant is defined in a separate set of statutes not connected to WRD that basically says your principal assistant must report to either the director or a deputy director. So what that essentially means is agency structure is not in alignment with what that statute says. So the provisions in this bill provide a small technical fix that requires the department to employ a registered professional engineer responsible for implementing the functions of the dam safety program, rather than linking it to this other definition of principal assistant that requires that staff person to sit in a specific spot within the agency. So it still requires that engineering expertise, but gives a little more flexibility for where that position can sit based on the needs that the department is providing to the state at any point in time. The next item is a House Bill 3342 technical fix. So 3342 was one of those large process improvement bills that passed back in 2025. This one is a very small technical fix that fixes a drafting error that will essentially just allow the department to implement the provisions that allow a proposed final order to become a final order automatically, provided that no protests are received on that proposed final order. So there's a drafting error that just kind of made it not really implementable. So this is a technical fix that just restores the language to be what the legislature intended the passage of that bill to do. The next item relates to the Conservation Reserve Enhancement Program authority that we have, and it expands that authority. So this provision in the bill provided the department the authority to explore and establish conservation reserve enhancement programs for groundwater right retirement in areas of the state where we are no longer issuing groundwater rights for irrigation. And then it also gives us the authority to enter into grant agreements, direct payments, and contracts with participants of the program. So this is a provision of the bill that does not have any fiscal impact. It doesn't impact the Harney program. We will continue implementing that one and the money that we have already have in our base budget to continue working on CREP in Harney. What this bill just says is continue doing that. Look for other areas. We will continue to do that at the time where one of those areas are identified. CREP takes a very long time and many, many conversations with the federal government, local entities in the area. So at the time that another area is identified, the department will come back to the legislature and ask for more resources when the time is appropriate. But the direction, the understanding with the legislature is not that we are going to all of a sudden go stand up CREP everywhere in the next 6 months. That's not what the intent there is. And then the last piece of this bill relates to permit extensions. So this also has some nexus to House Bill 3342. If you recall, one of the provisions within that bill repealed the extension of time pathway to develop water right permits for permits other than municipal, quasi-municipal, and group domestic. So think irrigation, commercial, industrial, those types of permits. This bill basically said no more extensions for those types of permits. And it extended the development period as well. The provision in House Bill 4004 is a narrow reversion of that specific change by allowing those permits, so the non-municipal, non-quasi-municipal, and non-group domestic, to apply for a one-time extension not exceeding 7 years to complete construction and apply water beneficially if the department determines that construction and beneficial use application was delayed because of delays for other local, state, or federal permitting requirements for the project, or appeals at the local, state, or federal level to decisions made on that project, and the application must be submitted within the completion date of the original permit or within the period of, if there's an existing extension, the extension cannot be expired. So if your permit, if you're outside your C date, if you're outside your extension date, this is not an option for folks there. So we want, the legislator's intent is to ensure that extensions and permits are active who have the ability to apply for this. So there's a lot in that bill. Before I move on, I want to pause and see if there are questions. I just talked a lot about that one particular bill. Okay, great. I will skip over House Bill 4049 because Director Gall already covered that. The other bill I will highlight is Senate Bill 1585, and this is a bill that reduces and caps grant match requirements for small municipalities. Our feasibility study grant program and the water project grants and loans program are implicated by this bill specifically. I will spare the details, but what the bill essentially does is it creates a sliding scale of the maximum percent match requirement based on the population of a municipality. So lower match requirements for smaller municipalities and goes up to, I believe, 20,000 people. And then there is another sliding scale built in that further reduces that cap based on the grant award for some of those categories of cities. But the goal there and essentially the takeaway is that it caps the maximum match requirement for grants that specific agencies can require for the grant programs. And then House Bill 4084 is a permitting efficiency and economic development projects bill that is being run by the governor. And there are a litany of provisions in this bill. I will just highlight the ones that are relevant to the department. So one key provision here is that it establishes a fast-tracked permitting council for projects that meet certain capital investment criteria and also require multiple permits in order to operate. The department, along with a litany of other natural resource and other permitting agencies, are directed to serve on this council and also participate in application fast tracking as necessary if a water right or transfer or whatever is required for that project. Another provision also directs agencies to develop a permitting catalog and also report to the governor on items that essentially summarize a variety of information about the permits that we offer. Some of this information includes authorities, fee history, what the current fee is, instructions for how to submit applications, and recommendations for streamlining the permitting process to achieve greater efficiency, which we've kind of talked to you all about. We've been doing quite a lot of work of that in the water rights sphere for the last couple of years. So we're doing good on that one. I think that's all I will highlight for legislation. I will note that I know we have consistently talked about budget being a conversation and budget adjustments being a conversation during the 2026 session. We have very little information on decisions that have been made or what decisions are on the table that the Joint Ways and Means committees are considering at this point in time. So if you can do the quick mental math in your head, they have about a week to make some decisions. So we anticipate that probably early next week is when more information will be available. So we'll be sure to keep you all apprised to how and if the department is impacted by any of those decisions. But we don't have any updates at this point in time. Go to the next.
I do have a quick question.
Yes, absolutely.
About Senate Bill 1585. Just for some clarification, did they talk about the size and what constitutes a small municipality?
Yes, Vice Chair Smitherman. So the bill, and I'm happy to send you the actual bill language, it sets thresholds. I believe 20,000 is the largest city, and then it sets further thresholds going down from there for smaller cities, and then it subsequently reduces the match percentage. So those are, I think the largest small city is I think around 20,000, and then it ratchets back down based on smaller population size.
Okay, it's based on population and not on number of accounts or services.
No, correct.
Okay. And then the reduced grant amount, we're just trying to figure out what in some of the grants that would be affected that we administer. Currently, are they around the 50% match, and it's being proposed to go to a 25%? Is that my understanding?
Vice Chair Smithman, so I need to pull the bill. I believe right now both of those programs are, our programs are 25%, a minimum 25%
Okay.
cost match. That was a change that was made in the 2025 session.
Okay.
I would need to pull the bill, but the requirements are in the bill are less than 25%.
Less than the 25%.
Yes.
Okay.
Yeah, so I can provide you with that bill language if you're interested in like what those numbers
Yeah,
actually
just
are.
curious,
Yeah.
but thank you. Any other questions before we go to the next slide? Yes, Commissioner Mall.
You mean, this may be an Ivan question too. The Fast Track Council, what who's gonna, like, who from the department, what levels the department would be on this council? I feel like it's gonna be a bunch of people in tracksuits and stuff.
Fast
But
track.
what, I'm really curious about this.
Yeah, Vice Chair Smitherman, Commissioner Moll. So we haven't dug too far into who would be representing the department. I do anticipate that depending on what type of transactions are needed from WRD specifically will depend on who we send. I suspect it will likely need to be a more senior level staff person, but it will likely depend on if it's a transfer or a water right or protest or something else. It would need to maybe be a little bit of a mix and match situation based on the specific permits that are actually in front of the council that are relevant to WRD.
And who convenes this?
The governor's office.
Okay, thank you.
All right, so now we're going to transition into discussing 2027 budget and legislative development. So we just talked about short session. Now we are moving into the long legislative session that happens in odd numbered years. This session usually goes from mid-January to the end of June, and this is where we tackle biennial budgets, larger policy issues, and key performance measures that are adopted or added or taken away or amended by the Joint Ways and Means Committees. Development schedule and instructions are handed from the Department of Administrative Services and the governor's office to executive branch agencies. So we have timelines that we meet that are given to us by DAS and the governor's office. Go ahead and go to the next slide. So I know we've already seen this timeline before, but we did receive some updated instructions with some actual concrete dates. So we wanted to be sure that you all had a good sense of the actual dates that we are marching towards. So we are currently working in the LC development or legislative concept development stage right now. We have been very preoccupied with the legislative session, so we will have limited information to share with you on kind of where we are at on that. But the deadline that we are working towards is April 10th, which is when legislative concepts are due to the Department of Administrative Services for consideration for moving forward. They will have until May 29th to make a decision about whether or not they want to submit an agency recommended legislative concept for drafting. So just because something gets submitted on April 10th, that does not mean that it is automatically going to be moving forward as part of our policy agenda for 27. So I think that's an important clarification to make. Should a bill make it past that deadline and it's decided that it's going to move forward, Legislative Council, so another fun LC adjective, Leg Council, who are the smart lawyers over in the building, will get to drafting legislative concepts. And at some point in October, it's happened in September, it kind of just depends on where your bill falls in the stack, you will get a draft back and we will have a certain amount of time to submit amended language if it's either drafted incorrectly, if conversations with you all, with the governor's office, with interested parties has changed the direction a bit or fleshed details out. That will be another opportunity that we have to submit additional language for our legislative concepts. But October 23rd is essentially kind of the pencils down part of that. At that point, pre-session filed bills will be submitted on December 11th. The important caveat here, and I'll make it when we talk about budget as well, is we are in an election year. So depending on the outcome of the gubernatorial race, decisions made now may change at a later date. We can't control that. So we're going to just keep following this deadline. So, but just a bit of a something for you all to keep in the back of your mind is that because we are an election year, things could change. Go ahead. Yep. So in terms of legislative concepts, the criteria that we're normally considering hasn't changed very much from the last time we presented. We're using our strategic plan and IWRS milestones as kind of our North Star. We are looking at statutory sunset dates or results from court findings that need legislation to address. If there are any technical issues with the program, we're also prioritizing those. New information that we did receive from the governor's office is that all concepts, and this is the same for POPs, for policy option packages, need to be revenue neutral. So that means if we want to pay for something with new money, we need to find it in our existing budget. So I think that's an important thing to keep in mind. And that will heavily influence the potential topics that we consider. Some of those items are the Deschutes mitigation, groundwater mitigation program that has an upcoming sunset date of 2029. So that is a topic that we are looking into. Harney Conservation Reserve Enhancement Program, that was a revisiting concept from the last 2025 session that allowed some flexibility for having another funds account created so we could roll money over and compound money and kind of start building the fund. There were some technical issues with the way that bill was drafted. And so, we're considering options to bring that forward again. We're looking at some of our spending authorities and grant making authorities, and then where there are options around water data as well, which I realize that those are pretty vague topics. We are still kind of trying to vet items that we have previously talked about in the context of this new criteria, especially that revenue neutral criteria as well. That does change how we kind of consider those concepts. And then budget development, again, you've all seen this slide before, but it's nice to remember that the budget process really has three distinct phases. The agency request budget, which is our menu of options that we provide to the governor's office and Department of Administrative Services. We're typically doing that in July is when the binder closes on that, right, Lisa? And then the governor has until December to publish their recommended budget. And then from there, that is our starting point for negotiations with the legislature to ultimately get to the legislatively adopted budget. So we really won't know what our budget looks like until June 2027. So we have a long path ahead of us. And again, as I caveated with the legislative concepts, we are in an election year. So that December deadline with a GRB, depending on the outcome of that governor's race, it could change. And then we did get some other deadlines that I just wanted to let folks know. It very similarly mirrors what we see with Ledge Concepts. So April 17th is when policy option packages, or POPs as we call them, are due to the Department of Administrative Services. Those will then get approved by DAS to continue moving forward and continue to work. And then we're largely looking towards the end of July for when our ARB document, or our agency request budget, is consolidated and published. And then the GRB is a December 1st release date, pending those other things that I've already mentioned. So, all right. And then we do have some updated policy option package criteria that we have received from the governor's office. So I will just at a really high level go through some of these, but you'll see the bolded revenue neutral language again, which is a big one. So items that prioritize investments that support economic development, so job creation, business growth, expanding the state's revenue base, things like that are part of the criteria that we've received. Implementation of recent executive orders. I think you all were briefed on that earlier today from the governor's office, so I won't belabor those. Things that address affordability, so prioritizing investments that make everyday life for Oregonians more affordable. Improving customer service and agency program efficiencies, so modernizing service delivery, streamlining processes, things like that. Protecting Oregon values, those are things like that focus on upholding civil rights, access to essential services and state authorities, core programs and services. So reading between the lines there, that is please don't suggest new programs or massive expansions of existing programs. And then net revenue neutral concepts, or concepts that do not require new revenue. And so what that means is if there's anything that does have a revenue impact, we would need to self-fund that. So things that we are looking at for potential areas of focus, similar to LC's, this new language or these new requirements we need to look at those and evaluate things that we have had previously on the list for fitting into this criteria are information technology, looking at what resources may be needed to implement the climate resiliency executive order, legal expenses, and then any outcomes from the 2026 session, any potential reductions that we may face, holding space for if there's anything that is reduced that we might find important enough to try to ask for back, and do some bean counting elsewhere to try to make that work is essentially kind of where we're at on that one. So to wrap up, we are planning to start engagement after the 2026 session concludes. So we are looking to do some formal engagement with interested parties as well as the federally recognized tribes in the spring. Keeping those other deadlines that we have gone over for POPs and legislative concepts in mind, but we will likely continue that outreach and engagement beyond those deadlines, just given that we have opportunities to continue working legislative concepts really until the start of session. So we will likely use that time to do so. So we are just in the very beginning. I know it seems like those deadlines mean that we've run out of time, but we're really just getting started. And then I think I've already highlighted that the legislative and budget areas of focus may change based on conversations with you all, with the governor's office, whether it's this governor's office or a new governor's office, and interested parties as we start engaging in formal discussions with them. So with that, it would be wonderful if I could answer any questions, if you all have feedback on some of the potential areas of focus. I know I tried to wrap up and get us all out of here early, but we are here for as long as you all want to discuss legislative and budget. So. And also, I didn't ask Lisa if she wanted to add anything.
I think you did a wonderful job.
Oh, yeah.
Yes, wonderful job. Thank you. Thank you, Brennan and Lisa. Commissioner Newman?
I just want to make sure I understand this. So policy option packages usually, or at least often, involve new money, right? I mean, new requests for funding. Legislative concepts can or can't, but so you're being asked to do both with no new money this time, and it's not like, I mean, often it used to be you'd sort of submit 3 budgets, 5% cut or whatever, a cut, stay the same with cost of living or something, and then the policy option packages or new things you wanted. So you're not going to get to do that this time. Is that right?
Vice Chair Smith and Commissioner Newman, that is correct. Or we'll have to make decisions about things that have existing funding and reprioritizing and
Well, that stinks. Sorry.
Yes, Commissioner Lee.
What happened to the budget cuts that were sitting on the table just a couple months ago? Did those go through or they got tossed?
Vice Chair Smitherman, Commissioner Lee. So those are part of the budget discussions that we anticipate will happen next week. We have not heard any new information since the department did present to that committee. Since the legislative days have essentially kind of convened, the Joint Ways and Means Committee has been tackling those recommendations that they received from their subcommittee, so the Joint Ways and Means Natural Resources Committee. And then there's also been a litany of conversations happening around transportation funding, as I'm sure folks have been privy to, that have really kind of been a big focus of this session. And I think those conversations, once those resolve themselves, more comprehensive discussions around the budget will happen next week. But we do not know what is happening with those at this point in time.
Thank you.
Yep.
Has there been thought put into the policies or procedures that could be implemented to meet the governor's executive order 2526?
Vice Chair Smithman, I'm not sure. That is some of the conversations that we are having are kind of dancing around that. I think there is some interagency coordination that is also necessary on that, because we are not the only agency that is implicated by that. So we are having some conversations and considering what that looks like and whether or not there needs to be sequencing of another agency doing something before us before we can do what we need to do. But we are also we are evaluating options within that, but given kind of the net revenue neutral requirements,
That's
I
my
think
concern.
yeah, it's an interesting Jenga puzzle that we are trying to put together.
And I figured you didn't have it all flushed out yet. But you know, that like Commissioner Newman said, that's unfortunate that there won't be any more funds to help support some of those new programs, and have to be really creative about how you're coming up with money to support those new orders. So thank you. Any other questions from commissioners? Commissioner Mall?
And somewhat related with I think most of the conversations have been around the kicker and the impact of a new economic forecast model and approach on that. But has there been any hints of guidance on how the budgeting process for you may change with this new approach to forecasting?
Chair Smitherman, Commissioner Mall, the information that we are receiving in our enterprise-wide meetings is that the budget approaches will be relatively similar to last go around, with the exception of the revenue neutral piece.
Vice Chair Smitherman, members of the commission, just kind of adding on to that, it's good to know now that revenue neutral is a rule.
Mm-hmm.
That does save us a significant amount of work of putting forward some larger pops that aren't revenue neutral. It takes a significant amount of staff time, particularly on Lisa's part and Bryn's part, to scope those out and put costs associated with them. So we are appreciative of the guidance that came early this year. That's a positive.
Instead of doing all this work and then being told you need to cut the budget by X percent. Yeah. Commissioner Newman?
One last question. Is that primarily because of federal fund cuts, or is it just a new austerity for Oregon or something like that? And also regarding the kicker, is there ever going to be any serious discussion of not kicking the kicker back? I mean, it's great to get a check, but still. Okay.
Now.
Maybe we will be here till 5. Just kidding.
You don't have any
do you want to-
public left. Oh, Kimberly's there. Okay.
Yeah, don't worry. You got it wrong.
Okay. So I think if I'm remembering correctly, the question was, or if Bryn helped me on this one, the question was around why the revenue is as it is. The most recent revenue forecast came out early February. It was a little bit better than the previous, but it wasn't up to what we expected as we were building into the LAB. And so, and the majority, my understanding is the majority of the buffer, that the increase was related to carryover unspent money from 23-25 biennium, and so not new revenues and things like that. So the revenue forecast is relatively flat and not allowing for that.
And so that doesn't have anything to do with federal. I mean, it's the Oregon income tax revenue, basically, right? Or does it include federal funding?
It's my understanding that there is some estimates around the decrease of federal funding coming into Oregon that are contributing to that.
Okay,
revenue forecast.
Do you know, maybe Raquel, Senator Przansky in the beginning of session did have a bill to bring back some portion of the kicker specifically for wildfire and maybe some related natural resources work. Did that go anywhere? Does anybody know?
Raquel, without knowing a bill number, Raquel won't know. Sorry. Without knowing a bill number, I would have to do a little bit of research, but I haven't.
Okay.
None of that has come across my desk from a significant policy work perspective.
Okay, thank you. That's too bad.
Do we have any more questions? Comments? Okay. Thank you so much for the presentation and for all your work on this. I know
Thank
it's
you,
a lot.
commissioners.
Yes. Okay, with that concludes our agenda for today. So we will adjourn and we will reconvene tomorrow at 8 a.m.